Hearing the appeal of Oceanbulk Shipping and Trading against TMT AG Limited and others.
May it please the Lordships, in this matter I appear with Mr. Leadbeater for the appellant, TMT, and Milano friend Mr. Schaff, Queen's Counsel, and Mr. Willen appear for the respondent. As you will be aware from the decision in the Court of Appeal, the question you were asked is how much oxygen is available at this elevated judicial altitude. More specifically, the question is whether or not material which forms part of the factual matrix against which a settlement agreement was made is admissible at trial as an aid to the interpretation of that agreement, notwithstanding that the material emerged in the course of without prejudice negotiations. And as I'm sure you're also aware, there are two subsidiary points, whether the same material is admissible in relation to a plea of estoppel, excuse me, and whether it's admissible in relation to a plea of remoteness. Just by way of a very brief roadmap, I was going to address you extremely briefly on the facts. Secondly, just to identify what is and what is not in issue, and then to take those three issues in turn: admissibility in relation to interpretation, in relation to estoppel, and in relation to remoteness. So far as the facts are concerned, obviously you've seen the statement of facts and issues, and I can take them very lightly. You know that the substantive dispute is concerned with alleged breaches of a settlement agreement which was made in June 2008, and if you haven't already found it, that's page 73 of the appendix. The agreement arose out of a number of freight forward swap agreements, which are known as FFAs for short, which are essentially bets made between contracting parties as to which way various designated freight rates will move over a given period of time, and then there are monthly payment triggers, depending on who won or lost in any given payment month. In the early part of 2008, the market was moving against my client, TMT. In the latter part of 2008, it moved spectacularly in TMT's favour. The question for trial is simply who owes who what under the settlement agreement. One of the background facts, which we will seek to explore, concerns the extent to which Oceanbulk's agreements, FFAs, with TMT were sleeved, which is a term of art in this market. In other words, had Oceanbulk entered into back-to-back agreements with third parties whenever it had entered into agreements with TMT, such that any liabilities it owed to TMT would be matched by equivalent debts owed to Oceanbulk by other counterparties, and any debts owed to TMT to Oceanbulk by TMT would be matched by equivalent liabilities owed by Oceanbulk to other counterparties. And those are what are called the opposite market positions that Oceanbulk either did or didn't enter into.
Is this like laying off bets?
In a sense, yes. Yeah.
It's essentially a back-to-back transaction with the one back not disclosed.
Yeah, exactly.
But is the issue whether they were in fact sleeved or whether it was represented that they were sleeved so that the parties should be treated as having contracted on that basis?
Both are going to be explored,
Yes.
but in relation to certainly in relation to the estoppel argument, we are indifferent as to whether or not they were sleeved.
Yes.
In any event, as your Lordships are aware, in June 2008, Oceanbulk and TMT agreed certain payment terms at a time when Oceanbulk was in the money, and a significant part of the dispute at trial will concern the interpretation of Clause 5 of the settlement agreement. I don't know if it would be convenient just to look at it very briefly now. As I say, it's page 73 of the appendix is where the agreement starts. There are a number of ancillary provisions with which we are not concerned. The only clause that we are concerned with, or the clause that gives rise to the issue with which we are concerned, is over the page, Clause 5. In respect of FFA open contracts between TMT interests and Oceanbulk for 2008, the parties shall, and then they do two things. The first is that they crystallise, and this is not a contentious issue, they crystallise within 10 trading days following 26th of June 2008 as between them 50% of the FFAs, so they crystallise half of the open FFAs at the average of the 10 days closing prices for the relevant Baltic indices from 26th of June 2008. That's not the contentious bit. The contentious bit is what then follows. They will cooperate to close out the balance of 50% of the open FFAs for 2008 against the market on the best terms achievable by the 15th of August 2008. Now, whatever that means, it didn't happen. The dispute between the parties is what it does mean, and therefore, in a sense, who is at fault for it not having happened. Just so that you know the context, as I say, it doesn't matter because this is not what you're deciding, but the context in which the dispute arises is that TMT, my client, says that what is contemplated by this bit of Clause 5 is a triangular process which would involve the parties, TMT and Oceanbulk, cooperating to ensure that Oceanbulk's opposite market positions with its other counterparties are closed out first, and then negotiations would be had between the parties, TMT and ABST, to crystallise their FFAs at rates to be agreed between them.
Sorry, how are you going to help Oceanbulk close out their back-to-back agreements?
It is a question of going into the market and seeing what rates are available in order to do that. And Lord, the point that TMT takes is that Oceanbulk never initiated that process, and indeed, despite requests, Oceanbulk actually failed to disclose any of the details of its opposite market positions to TMT. And so we say that it was Oceanbulk that was in breach of the agreement. The converse argument, Oceanbulk's argument is no, this bit, these 2.5 lines in Clause 5, contemplate a bilateral, a two-way process only, namely that what was being agreed simply was that Oceanbulk and TMT would negotiate to close out between themselves their mutual FFAs, and they say that we were the ones who were in breach of that agreement because we didn't agree with them the terms for closing them out. So that is the interpretation dispute which will be run at trial. You're obviously not concerned with the merits of either party's substantive position, but that at least shows to you why the dispute has arisen.
Can I just ask a question? You said you gave us a definition of sleeving a moment ago, which was identical with back-to-back, i.e. The back-to-back contract might be with a third party completely unknown to TNT and Oceanbulk. And my question has something to do with what you've just been saying. The definition, actually, in the statement of facts of sleeving is completely different. Paragraph 10, the definition is that the third-party transaction is one which one of the parties to the main contract has asked the other party to enter into.
Lord, yes, Lord, one of the elements in sleeving is that request. I'm sorry.
Then, of course, that certainly has a bearing on, one would have thought, on the issue you've just described, as to what cooperation means.
Yes, indeed. Sorry, I was taking it rather shortly. I wasn't trying to depart from what the definition of sleeving in the statement of facts initially. I was taking it rather rapidly, just in order to draw to your attention the actual clause in the contract that we're talking about. Lords, as you will probably be aware, all that has happened in procedural terms that has brought this matter to this court is that two sub-paragraphs in our what is now a re-amended defence and counterclaim have been struck out. Those are to be found, for your note, it's page 98 of the bundle of the appendix. The pleading actually starts at page 90. And you'll see at page 98, we plead in relation to the interpretation of that provision that I just read to you, paragraph 18, we say, as to paragraphs 20 and 22 of the particulars of claim, one, as to the proper meaning of cooperates to close out against the market, it is averred that one, and this has not been struck out and is not in issue, this section, in the negotiations leading to the signing of the settlement agreement, Mr. Pappas of Oceanbulk represented to Mr. Nobu Su of the defendants that the swap agreements Oceanbulk had entered into with the defendants were sleeved transactions. By way of particulars of that allegation, one, and again this is not in dispute, in an email dated 1st of June 2008 from Mr. Pappas to Mr. Su, Mr. Pappas said of Oceanbulk's impending cash flow problems in the event that the first and second defendants didn't pay the May 2008 settlement sums, that most of this position is in any case due to the sleeves we did for you when you asked us in the past in order to assist. So that is evidence which we are entitled to adduce at trial. It's not been struck out, and so that is going to be part of the material at trial. Subparagraph 2, at a meeting on 5th of June 2008, attended by Mr. Su and Mr. Richard Lee of TMT, Mr. Spark of My Instructing Solicitors, and Mr. Pappas and Mr. Earhart of Oceanbulk, Mr. Pappas stated that he had sleeved TMT's trading at Mr. Su's request. And again, evidence in relation to that has not been struck out. That paragraph stands. The two subparagraphs which have been struck out by the Court of Appeal are the two that then follow. It's 3 and 4. In an email dated 10th of June 2008 from Mr. Pappas to Mr. Su, Mr. Pappas asserted that Oceanbulk had had to pay $40.5 million on Mr. Su's behalf for the May 2008 contract month. Lord, that is one of the paragraphs that's been struck out, and although the email itself is not in dispute, and it's to be found at page 72 of the bundle if you are curious. And then paragraph 4...
You say it's not in dispute, it's still not admissible.
The email as a document is admitted as a document.
But not its admissibility.
Its admissibility is what is in issue. Paragraph 4 is the other subparagraph which has been struck out. At a meeting on the 19th of June 2008, attended by Mr. Su of TMT, Mr. Spark of INTS, Mr. Pappas, Mr. Earhart, and Mr. Softland of Oceanbulk, Mr. Hawkins, Mr. Pitlarge, and Mr. Lee of Hill Dickinson, who were then acting for Oceanbulk, and at a meeting on the 20th of June, attended by most of the same people, Mr. Pappas again asserted or allowed the negotiations to proceed on the assumption, which itself was the result of the representations particularised above, that the swap agreements were sleeved. So that paragraph is gone so far, subject to your decision. And then we go back to the text which has not been struck out, and it was in reliance upon that representation, or those representations, that the swap agreements were all or substantially all sleeved, that the defendants agreed to clause 5 of the settlement agreement, and that representation, or those representations, both parties understood that in respect of each swap agreement Oceanbulk held with the defendants, Oceanbulk held an opposite position with other participants in the FFA market, in particular Cargill, so that the liabilities of the defendants had to Oceanbulk under the 2008 FFAs were equal in amount to liabilities Oceanbulk had to counterparties on equivalent swap agreements. So that is the pleading in which the material that has been struck out appears. It's just subparagraphs 3 and 4, not 1 and 2. We'll come back to estoppel, which is paragraph 1A at the foot of the page. I'll deal with that separately later. But you'll see just over the page, at page 100, is TMT's interpretation of clause 5, or the contentious bits of clause 5 of the settlement agreement in little Roman 2 near the top of the page. The words "cooperates to close out against the market" arose out of the parties' negotiations leading up to the settlement agreement, and in particular, in the light of Mr. Papps's representation or representations that his swap agreements with the defendants were sleeved, it is averred that the words meant, in the context of the relevant negotiations, that first the defendants would, if Oceanbulk so requested, assist Oceanbulk to agree fixed figures payable by Oceanbulk to counterparties to close out Oceanbulk's opposite market positions. Oceanbulk would then close out Oceanbulk's opposite market positions, Thereafter, the FFAs between Oceanbulk and the defendants would be crystallised at rates to be agreed. So, in other words, that is just the pleaded position. Those are the issues that will arise at trial, and those are the pleadings which have and have not been struck out. As you will no doubt be aware, the question whether or not the passages that have been struck out, and indeed the passages that haven't been struck out, whether they are indeed relevant to the interpretation of the contract, will be a matter for dispute at trial. But for the purposes of this appeal, the legal issue of admissibility has proceeded on the assumed basis that the evidential stuff that we have pleaded and which has been struck out is relevant, or, the learned friend say, capable of being relevant for the sake of this argument, as part of the factual matrix against which the contract falls to be interpreted. So your lordships are deciding this discrete point of law on the assumed basis that what has happened in the court below is that relevant factual matrix evidence has been declared to be inadmissible because it emerged in the course of without prejudice negotiations. And that is the narrow point, the main point. Now, in addressing that central issue of the admissibility of these two paragraphs of evidence in aid of interpretation, we are, in summary, saying three things. Now, I just want to make very clear at the very, very outset of our submissions how we're putting our case. The first and main argument that we offer to you is that the disputed material in this case ought to be admitted because it serves exactly the same public interest as the without prejudice privilege. Its admission, that is, serves exactly the same public interest as the without prejudice privilege. Our principal argument is not that we are invoking some different or higher public interest which outweighs the public policy on which without prejudice is based. What we are saying in our main argument is that the admission of this evidence actually promotes the public policy on which the without prejudice privilege is based. I will obviously develop each of these, but I just want to get the structure of the argument firmly in place first. The second argument we offer in the alternative is that if, contrary to our main point, there is some conflict between the policy on which without prejudice privilege is based, on the one hand, and the admission of this disputed material on the other hand, if there is some conflict, then there is a balancing exercise to be conducted, and we would submit that the balance falls firmly in favour of admitting this material rather than excluding it.
For that, you must rely upon some other principle as being dominant.
Yes. And the third submission we make, although we don't need to make this, is the one that's been referred to in our case as the alternative argument, which is simply, in a sense, an offer to this court for what worth, that one way of bringing some clarity and consistency to the law on without prejudice would be to adopt a somewhat more principled approach by saying that as a matter of policy, where two parties have reached an agreement on the basis of without prejudice negotiations.
Can you take it a little more slowly? As a matter of policy, where
two parties have reached an agreement on the basis of without prejudice negotiations, and a dispute subsequently arises between them in relation to that agreement, the public policy which would otherwise prevent disclosure to the court of any without prejudice material
Which would
otherwise prevent the disclosure to the court of any without prejudice material passing between them is spent, and the material ought generally to be admissible.
Now that's giving imposing a gloss on the effect of a without prejudice agreement when you say it's something that stops you disclosing to the court. Because if there's an issue about whether it is or is not admissible, the court's got to see it. Surely the without prejudice agreement prevents the material which is disclosed to the court having any effect in the relevant litigation.
Lord, yes. Sorry, when I said that the material, the closing line of this general proposition is that the material ought generally to be admissible rather than inadmissible. So the difference between, so we have these three arguments, and I just want to sort out the difference clearly between them before I get into the detail. The first and the main argument is essentially based on the proposition that there is no conflict between the public interests which we say is served by the admission of this material and the public interest upon which the without prejudice privilege is based. There is simply no conflict. They are in fact serving the same master. That's our first point. Second point is simply on the facts of this case, if you're not with me on my analysis for the first one, on the facts of this case, the balance of factors results in the public interest in admitting this evidence outweighing the public interest in excluding the evidence, simply by reference to the facts of this case. The third point we make, the alternative argument, in a sense is an extension of that second point, but it is a principled extension, and the suggestion that we offer to you, as I say, we don't have to offer it, we don't have to win on this point in order to win the appeal, we offer it for what worth. The third point is that you could reach the conclusion that where there has been a settlement agreement on the basis of without prejudice negotiations, then the public interest which hitherto would have precluded the admissibility in court proceedings of the without prejudice negotiations, that public policy is spent in relation to disputes between the parties about that settlement agreement, not more generally.
So if there was a dispute about the meaning of the settlement agreement in proceedings involving another party, it would be given a different meaning, would it?
It would be,
or might be.
It might be. It would. The material which could be deployed in court would be different. My Lord, as I say, if that is not a result that your Lordships find attractive, then we are agnostic on whether you accept it. But as I say, simply through essentially just researching the points, it occurs to us that your Lordships may find it an opportunity to bring, as I say, some clarity to what is quite a difficult area of the law, with some decisions which are not always entirely easy to reconcile. Now, Lord, having identified those three separate arguments,
Could I just pause a moment? There might even be a wider argument that the without prejudice element is without prejudice to the particular dispute in relation to which the material is disclosed or statements are made, but that if thereafter the parties enter into maybe a quite different contract, they can nonetheless refer to that material, because the alternative is going to produce, or could produce, a very artificial situation if the parties enter into a contract, the effect of which depends critically upon what they knew or some piece of background.
Indeed. Lord, as I say, having identified those three conceptually separate arguments. A lot of the reasoning, the progression towards each of those three arguments shares very much many of the same steps. And so I'm going to approach them cumulatively, and then obviously tell you when we come to the trifurcation of the road. And what I wanted to do was to start simply with some, I hope, completely uncontentious observations about the admissibility of evidence of the factual matrix in construing contracts. This is not, as I say, contentious or new stuff. It's trite law that relevant evidence of the factual matrix in which a contract was made is admissible as an aid to its interpretation. We would suggest, and it may be convenient just to go to a very short article by my Lord Bingham on this point, we would suggest that the underlying philosophy behind the admission of factual matrix evidence in the generality of cases is that the court regards its job as being to give effect to the reasonable expectations of honest men by providing an effective and fair framework for contractual dealings. And Lord, that is a quotation, as I say, from some material that Lord Bingham himself quotes in an article in the third Authorities volume at tab 56.
Mine seem to be labelled 6, 7 and 8.
Yeah. Yes, somewhat unhelpfully, I think the volume 3 has come out looking awfully like 8.
See.
So you've got the volume 3.
I see.
Yes, fortunately there are 5 missing volumes.
Sorry, which tab?
We're in tab 56, my lord. And this is a relatively short piece written by Lord Bingham as apologia, defence, justification for the decision in ICS and West Bromwich, which had been criticised from some quarters as being revolutionary, radical, departing from established approach. And Lord Bingham's argument here is essentially that ICS and West Bromwich changed nothing. We had been living in the same world for some considerable time. Now, I don't think I need to take you through the detail of it for that, but what I did want to do was just to draw to your attention on the second page of the article, page 375 of the document itself, where he says, near the top of the page, he's talking about what the courts have to do, and then you'll see there are 2 indented quotations, and just above them he introduces them. He says, there is probably agreement on the broad objective to be achieved. As Lord Gough of Cheveley put it extrajudicially, we are there to help businessmen, not to hinder them. We are there to give effect to their transactions, not to frustrate them. We are there to oil the wheels of commerce, not to put a spanner in the works, or even grit in the oil. And as Lord Steyne, also extrajudicially, made very much the same point, when he said, a thread runs through our contract law, that effect must be given to the reasonable expectations of honest men. The function of the law of contract is to provide an effective and fair framework for contractual dealings. The problem, of course, arises when one tries to give practical effect to these laudable aims, and then he goes into the detail. But I just wanted to park with your lordships those thoughts about essentially what is, it's rather elementary stuff, but essentially what is the court's function when it is interpreting business contracts. And obviously the point more specifically in relation to the admission of factual matrix evidence is essentially this, if one could just summarise where the authorities have gone to and then very briefly remind you of some of the key passages. Where we seem to have got to is this, my lords, that the meaning of a contract is the meaning it would convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties at the time the contract was made. That is why.
Are we going to see that quoted, or are you going to repeat it?
My Lord, I will give it to you.
It's in your case, isn't it?
I think it is in our case.
Paragraph 14.
I'm obliged. Paragraph 14. And that is the rationale for admitting evidence of background facts. And we suggest that the development of this principle for the admission of the factual matrix, as it's generally called, is founded upon the judicial insight that parties to a contract often use language in a way which an uninformed third party might not expect. Now, as I say, none of this is controversial or new, but we do suggest that it will assist the court if we can just remind ourselves of the rationale, partly because this is exactly the process which Oceanbulk says should not happen in this case. They're saying the court should not be informed about the factual matrix because it emerged in the course of without prejudice negotiations. And partly I also want just to put into your minds some of the ways that the courts have put what they have said about the admission of factual matrix evidence, because it has a very strong resonance when we get to the principled approach to the admission or non-admission of without prejudice material and the various situations which have already been identified, principally drawn together by my Lord, Lord Robert Walker in the Unilever case, as to the circumstances in which material can be admitted, notwithstanding that it is without prejudice. So I just want to spend a little time taking you through some authorities with which many of you may well be fairly well familiar already, but I just want to do it quite quickly and quite lightly to bring these principles to the forefront of your Lordship's mind. The first one is the oldest. I'll take them in chronological order. River Weir Commissioners and Adamson. It's V2, tab 34. And this is, I cite this partly because it's cited in the late authorities and also in the article by Lord Bingham to show the antiquity of the approach that Lord Hoffman, principally in ICS and Bromwich, was taking. What was in fact being addressed in the River Weir Commissioners and Adamson was a question of statutory interpretation, but what was said was of general application. I needn't take you to the circumstances. The question was that they were addressing was whether or not a statute did or didn't impose a new form of personal and strict liability. But the circumstances don't matter. We can go straight to page 763, where Lord Blackburn says that there is no doubt about the principles of construction of statutes, and he says just at the beginning of the paragraph, about a quarter of the way down the page, "My Lords, it is of great importance that those principles should be ascertained, and I shall therefore state as precisely as I can what I understand from the decided cases to be the principles on which the courts of law act in construing instruments in writing, and a statute is an instrument in writing. In all cases, the object is to see what is the intention expressed by the words used, but from the imperfection of language, it is impossible to know what that intention is without inquiring further, and seeing what the circumstances were, with reference to which the words were used, and what was the object appearing from those circumstances, which the person using them had in view. For the meaning of words varies according to the circumstances with respect to which they were used." Lord, I won't read on, but he picks up the same point just over the page, at the top of page 764, having cited some other authority. He says, "In construing written instruments, I think the same principle applies. In the cases of wills, the testator is speaking of and concerning all his affairs, and therefore evidence is admissible to show all that he knew. And then the court has to say what is the intention indicated by the words when used with reference to these extrinsic facts. For the same words used in two wills may express one intention when used with reference to the state of one testator's affairs and family, and quite a different one when used with reference to the state of the other testator's affairs and family. In the case of a contract, the two parties are speaking of certain things only, and therefore the admissible evidence is limited to those circumstances of and concerning which they used those words. In neither case does the court make a will or a contract such as it thinks the testator or the parties wished to make, but declares what the intention indicated by the words used under such circumstances really is. And so that is, in our submission, an entirely orthodox statement of the correct approach, and it emphasises exactly why factual matrix evidence is admissible, because of the imperfection of language and the different intentions that can be applied, that can apply in relation to the use of the same words. Lord, that is then followed, staying with the same bundle, at tab 29, with Pren and Simmons. Again, well known, I'm sure, and orthodox. Tab 29, again, the facts don't matter. We can go straight to the speech of Lord Wilberforce at page 1383. The last two lines on 1383. In order for the agreement to be understood, it must be placed in its context. The time has long passed when agreements, even those under seal, were isolated from the matrix of facts in which they were set and interpreted purely on internal linguistic considerations. There is no need to appeal here to any modern anti-literal tendencies, for Lord Blackburn's well-known judgment, the one we've just seen, provides ample warrant for a liberal approach. We must, as he said, inquire beyond the language and see what the circumstances were with reference to which the words were used and the object appearing from those circumstances which the person using them had in view. Moreover, at any rate, since MacDonald and Longbottom, it has been clear enough that evidence of mutually known facts may be admitted to identify the meaning of a descriptive term.
I seem to remember that we used to refer before these cases, to a Privy Council case with an impossible Finnish name, Osakieti, of the 1930s, which was in the commercial law reports, which I think...
If you look in the next paragraph, you'll find it referred to.
Yeah. Oh, good. It's right, I've got it completely wrong, but that's the one. Yes, that's exactly right. Yes.
Yes. Well, I wasn't going to read the next paragraph precisely because of the linguistic problem of pronouncing the plaintiff's name.
Actually, it's House of Lords, not Privy Council as well.
But Lord, your Lordship's absolutely right. Yes. And then, just carrying on quickly, the next case is at tab 32, the next case chronologically. My old Lord Phillips may remember this. Yes, Reardon Smith and Ingvar Hansen Tangen. And again, we needn't dwell on the facts. We can go straight to some general statements of principle, which appear in the speech of, again, Lord Wilberforce at page 995. And you'll see at 995 at letter E, he's talking about a contract for the building of a vessel. The contract is in the English language to be construed in accordance with English law. And then he talks about the material that's sought to be adduced. At letter G, he says it's less easy to define what evidence may be used in order to enable a term to be construed. To argue that practices adopted in the shipbuilding industry in Japan, for example, as to subcontracting are relevant in the interpretation of a charter party contract between two foreign ship companies, whether or not those practices are known to the parties, is, in my opinion, to exceed what is permissible. But it does not follow that renouncing this evidence one must be confined within the four corners of the document. No contracts are made in a vacuum. There is always a setting in which they have to be placed. The nature of what is legitimate to have regard to is usually described as the surrounding circumstances, but this phrase is imprecise. It can be illustrated, but hardly defined. In a commercial contract, it is certainly right that the court should know the commercial purpose of the contract, and this in turn presupposes knowledge of the genesis of the transaction, the background, the context, the market in which the parties were operating. And then he gives some illustrations, which I won't dwell on. He refers back to Pren and Simmons and some other authorities and the 1933 case we were just talking about. And just on the facing page at 997, letter C, he says, I think that all of their lordships are saying in different words the same thing. What the court must do must be to place itself in thought in the same factual matrix as that in which the parties were. All of these opinions seem to me implicitly to recognise that in the search for the relevant background, there may be facts which form part of the circumstances in which the parties contract, in which one or both may take no particular interest, their minds being addressed to or concentrated on other facts, so that if asked, they would assert that they did not have those facts in the forefront of their mind. But that will not prevent those facts from forming part of an objective setting in which the contract is to be construed. And then he goes on to apply that to the case in hand. And then just very briefly, two more cases, Manai and Eagle Star, which is in the same volume, tab 26. Starting again, we needn't dwell on the facts now, but I'll come back to Manai, because the question here, as your lordships may recall, was whether or not a notice purporting to exercise a break clause on the 12th of January could in fact be interpreted and take effect as a notice exercising break on the 13th of January. In that context, Lords Steyn and Hoffman both said a number of points which are useful just as general background on this point of law. Page 767 in Lord Steyn's speech. Letter G. So the question is not how the landlord understood the notices. The construction of the notices must be approached objectively. The issue is how a reasonable recipient would have understood the notices, and in considering this question, the notices must be construed taking into account the relevant objective contextual scene. The approach in Reardon-Smith, which deals with the construction of commercial contracts, is by analogy of assistance in respect of unilateral notices such as those under consideration in the present case, relying on the reasoning of Lord Wilberforce's speech in Reardon-Smith, so on. Three propositions, he says, can be formulated. First, in respect of contracts and contractual notices, the contextual scene is always relevant. Secondly, what is admissible as a matter of the rules of evidence under this heading is what is arguably relevant, but admissibility is not the decisive matter. The real question is what evidence of surrounding circumstances may ultimately be allowed to influence the question of interpretation. That depends on what meanings the language read against the objective contextual scene will let in. Thirdly, the inquiry is objective. The question is what reasonable persons, circumstanced as the actual parties were, would have had in mind. It follows that one cannot ignore what a reasonable recipient of the notices would have had in the forefront of his mind, the terms of the lease, given that the reasonable recipient must be credited with knowledge of the critical date and the terms of the clause. The question is simply how the reasonable recipient would have understood such a notice. And then in Lord Hoffman's speech, just picking up at page 774, at letter D, again a relatively well-known and oft-cited passage. If I could just remind you, 774, letter D, I propose, he says, to begin by examining the way we interpret utterances in everyday life. It is a matter of constant experience that people can convey their meaning unambiguously, although they have used the wrong words. We start with an assumption that people will use words and grammar in a conventional way, but quite often it becomes obvious that, for one reason or another, they are not doing so, and we adjust our interpretation of what they say, what they are saying accordingly. We do so in order to make sense of their utterance, so that the different parts of the sentence fit together in a coherent way, and also to enable the sentence to fit the background of facts which plays an indispensable part in the way we interpret what anyone is saying. No one, for example, has any difficulty in understanding Mrs. Malaprop when she says she is as obstinate as an allegory on the banks of the Nile. We reject the conventional or literal meaning of the word allegory as meaning nonsense, as making nonsense of the sentence, and substitute alligator by using our background knowledge of things likely to be found on the banks of the Nile and choosing one which sounds rather like allegory. Mrs. Malaprop's problem was an imperfect understanding of the conventional meanings of English words, but the reason for the mistake doesn't really matter. We use the same process of adjustment when people have made mistakes about names or descriptions or days or times because they've forgotten or become mixed up. If one meets an acquaintance and he says, "And how is Mary?" it may be obvious that he's referring to one's wife, even if she's in fact called Jane. One may even, to avoid embarrassment, answer, "Very well, thank you," without drawing attention to his mistake. The message has been unambiguously received and understood. Lord, there's similar at page 779, when he moves from the banks of the Nile to commercial contracts. 779 letter F. In the case of commercial contracts, the restriction on the use of background has been quietly dropped. There are certain special kinds of evidence, such as previous negotiations and express declarations of intent, which for practical reasons which it is unnecessary to analyse, are inadmissible in aid of construction. They can be used only in an action for rectification. But apart from these exceptions, commercial contracts are construed in the light of all the background which could reasonably have been expected to have been available to the parties in order to ascertain what would objectively have been understood to be their intention. The fact that the words are capable of a literal application is no obstacle to evidence which demonstrates what a reasonable person with knowledge of the background would have understood the parties to mean, even if this compels one to say that they used the wrong words. And this he is talking about the process of interpretation, you will remember. In this area, we no longer confuse the meaning of words with the question of what meaning the use of the words was intended to convey. Why, therefore, should the rules for the construction of notices be different from those for the construction of contracts? And he then again refers to Brennan Simmons and Reardon Smith. And then the final authority in this line is obviously ICS and West Bromwich itself, which is at tab 24. This was the case, again, you'll, I'm sure, remember it. What was being construed was assignments executed by investors in favour of the investor compensation scheme. But what was said is of general application. And again, Lord Hoffman, in his stride at page 912, at letter F, where he says he prefers the approach of the judge. And he says he will preface his explanation with reasons with some general remarks about the principles by which contractual documents are nowadays construed. I don't think that the fundamental change which has overtaken this branch of the law, particularly as a result of Brennan Simmons and Reardon Smith, is always sufficiently appreciated. Just by way of parenthesis, the one, I think, disagreement between Lord Bingham in his article and Lord Hoffman in this speech is simply on the question whether or not those cases represented a fundamental change at all. By reference to River Weir, Lord Bingham was saying that Brennan Simmons and Reardon Smith were themselves entirely orthodox, but that's just a footnote point. The result has been, subject to one important exception, to assimilate the way in which such documents are interpreted by judges to the common sense principles by which any serious utterance would be interpreted in ordinary life. Almost all the old intellectual baggage of legal interpretation has been discarded. The principles may be summarised as follows. Interpretation is the ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. The background was famously referred to by Lord Wilberforce as the matrix of fact. But this phrase is, if anything, an understated description of what the background may include, subject to the requirement that it should have been reasonably available to the parties, and the exception to be mentioned next. It includes absolutely anything which would have affected the way in which the language of the document would have been understood by a reasonable man. 3, 4 and 5, your lordships may also wish to cast an eye over, but essentially that is the core of the authority on this subject. And as I say, we just want to make sure that your Lordships very much have in mind what I hope is entirely familiar and not controversial, which is that the reason why factual matrix evidence is admitted as an aid to interpretation is in order to enable the court to come to the right answer. Because language is imperfect, it's imperfectly used, it can mean different things in different contexts, and in order to understand what objectively the parties to an agreement meant, the court admits evidence of the factual matrix. That is the first, in a sense, step along the road of our argument. The second step is a much smaller one, and it is simply to say this, that a settlement agreement should be interpreted in exactly the same way as any other agreement. There are no special rules that apply to settlement agreements. And if one needed authority for that, there is the decision in BCCI and Ali, which is in volume 1 of the authorities at tab 3. If I could just go to this very briefly, again, it's not contentious, so I can take it relatively lightly, but I do just want to emphasise this. This case, I think, was cited in argument in the Court of Appeal, but didn't feature in the judgment. So I just wanted to bring it to your attention. The factual situation that, against which this was decided was that certain former employees of BCCI were given a severance package in exchange for signing a release of any claims they might have against the bank. When the bank then went under, it sought to recover various loans that had been made to a number of employees. The employees then sought to counterclaim for injury to their reputations, effectively spoiling their ability to get new work by reason of their being tainted by association with BCCI. And the question that then threw up was whether the release that they had signed precluded them from bringing the counterclaims for injury to reputation. And the question was, well, what was the reach of the release? How wide did it go? Did it release those particular types of claim as well? Lords, the leading speech is given by Lord Bingham, which starts at page 257. And the relevant passages I'm just going to take you to briefly are page 259, paragraph 8. I consider first the proper construction of this release. In construing this provision as any other contractual provision, the object of the court is to give effect to what the contracting parties intended. To ascertain the intention of the parties, the court reads the terms of the contract as a whole, giving the words used their natural and ordinary meaning in the context of the agreement, the parties' relationship, and all the relevant facts surrounding the transaction so far as known to the parties. To ascertain the parties' intention, the court does not, of course, inquire into the parties' subjective states of mind, but makes an objective judgment based on the materials already identified. And
is that strictly true in this area, or do you not have to inquire what each party subjectively knew in relation to the matrix? Isn't that one of the objects of trying to introduce this material, to show what was known?
It only matters which are known to both parties, and therefore
yes.
A part of the objective matrix, isn't it?
I think so. I think if your Lordship is questioning the phrase, the court does not, of course, inquire into the parties' subjective states of mind, if what Lord Bingham was referring to was intention, then I think that would be orthodox. State of mind in the sense of knowledge.
Yes.
Your Lordship's right, yes. Yeah. And then on...
But I have an idea that in some of the formulations it is put in terms also of what they must be reasonably taken to have had in contemplation or something of that sort.
Yes.
That's how Lord Wilberforce puts it in Bren at top of page 1384. This being of no circumstances which the person using them had in view.
Yes.
So, and then something about it may
If there's a piece of special... a special fact which is not common knowledge, I don't see how you can really answer that question without looking at what was communicated between the parties.
But if it is common knowledge, then however special the information is, it would be relevant.
Yes, indeed.
It's a bit, this case is striking in the air, isn't it? I mean, it doesn't appear that the respondent argued for anything other than what the court held. It's a bit difficult to conceive what the alternative would be to construing the contract normally.
Well, paragraph 26, at page 265, Lord Nichols certainly deals with the question of whether any special rules could apply, and he says there is no room today for the application of any special rules of interpretation in the case of general releases. There's no room for any special rules because there is now no occasion for them. A general release is a term in a contract. The meaning to be given to the words used in a contract is the meaning which ought reasonably to be ascribed to those words, having due regard to the purpose of the contract and the circumstances in which the contract was made. This general principle is as much applicable to a general release as to any other contractual term, wherever should it not be.
I mean, the argument the other way was based upon what Sir Frederick Pollock had said in the passage of paragraph 24.
Yes. And over again, just to drive the point home at paragraph 29, Lord Nichols still, this approach, which is an orthodox application of the ordinary principles of interpretation, is now well established. And then Lord Hoffman at page 268, to like effect, paragraph 37, the passages have been sidelined, and I won't read them up because we're getting slightly repetitive now. Paragraphs 37 and 39, referring back to the authorities that you've been taken to. I'd simply cite this, not because it says anything new, but simply to emphasise that it applies equally to settlement agreements. And also paragraph 79 in Lord Clyde's speech at page 282. So, as I say, the second step in the argument is simply is a small one. It is that the same rules of contractual interpretation apply to settlement agreements as they do to any other kind of contract. The third step in the argument I just want to explore is the public policy justification for excluding without prejudice material in many cases. And so far as this is concerned, again, I don't think it is particularly difficult or controversial. The purpose of excluding without prejudice material from evidence is to encourage the settlement of disputes. And the means for achieving that purpose is to protect a litigant from being embarrassed by things he may have said, purely in an attempt to achieve a settlement. Again, we anticipate that these propositions are not controversial, but we do urge that it is very important to bear them firmly in mind at the very outset, because they do have a very significant impact on the later stages of the argument. So if you'll just allow me, I'll just spend a few minutes again going through a couple of the authorities on this point to make good those two very short points. Starting, it may be convenient just to start with some academic commentary, because that sometimes does have the advantage of pulling together some different authorities without having to go to each case. And the first one I was going to go to in volume 3, tab 58. It's a long and detailed analysis by David Wever, which has been cited in other cases. And I just wanted to draw to your attention page 94.
So what's the date of this?
This is in 1970...
74, I think. I'm looking at the bottom of the page.
74.
Oh, that's the... That's
Yeah.
actually an accurate
74.
date. 74, yeah.
At page 94, under the heading The Conceptual Rationale of the Rule, He says the foregoing historical analysis of the English decisions has indicated the true modern basis of the without prejudice rule. It is considered sound public policy that parties to a dispute resolve their differences in a peaceful manner without being compelled to resort to the expense, delays, inconvenience and hostility engendered by litigation under the adversary system. In attempting to resolve their differences, the parties may well make admissions during negotiations for the purpose of showing their good faith and for smoothing the path to settlement. The difficulties of proving by direct evidence the contents of the admissions may be pointed out and may be an influencing factor towards a compromise. But if such express or implied without prejudice negotiations fail, no admission made during them may be used in support of the other party's case. To this extent, the courts are prepared to suppress truthful best evidence, since on balance the benefit of suppression, viz. The promotion of peaceful compromises, is considered to outweigh the not insubstantial possibility of a decision against the realities of the case through exclusion of an admission. The dictum of Lord Sumner in Russell and Russell, that it is best that truth should out and that truth should prevail, is overshadowed in this context by the consideration that it is best that compromises should be encouraged and that they should prevail. This outlook may perhaps be regarded as an aspect of a wider legislative and judicial policy, generally favouring extracurrial settlement, as indicated by the popularity of arbitration and the procedures encouraging early and realistic payments into court. Indeed, some judges punish a failure to settle by adverse awards of costs. My Lord, at the next tab there is another much shorter article and also a more recent article by Declan McGrath, and it's just the opening paragraph of that which it advances a similar proposition. The privilege granted in respect of communications in furtherance of settlement, commonly known as without prejudice privilege, is based primarily on the public policy of encouraging litigants to settle their differences rather than litigate them to a finish. The privilege thus promotes the settlement of disputes by enabling parties to discuss the relative strengths and weaknesses of their cases with complete candour, secure in the knowledge that anything said in the course of the negotiations cannot be used to their prejudice in the course of the proceedings. This public policy justification is reinforced by the convention or implied agreement that when parties engage in settlement negotiations on a without prejudice basis, they do so on the understanding that the contents of those discussions will not be used to the prejudice of either party. In recent years, there has been a discernible trend towards a rationale-based analysis of the privilege, and this is evident from an examination of recent case law in the area, which has sought to align the parameters of the privilege with the foregoing rationales, and that, in our submission, is an entirely correct and we would submit a helpful analysis. We also have the report, the 16th report of the Law Reform Committee, which is at tab 63. And we can just look very quickly at paragraphs 34 and 35, which are pages 14 and 15 of the text. Paragraph 34, it has always been regarded as being in the public interest that persons should settle their private differences without recourse to litigation, and if litigation is started, that it should be brought to an end by compromising as soon as possible, so that time and expense to the parties may be saved. The next sentence is not in point, but the report goes on, potential litigants may be inhibited from embarking on negotiations for a settlement which normally calls for mutual concessions on each side, unless they can be assured that what they say or offer in the course of the negotiations will not be used against them in the subsequent litigation if the negotiations fail. And at paragraph 35, before any privilege in respect of negotiations can rise, there must exist between the parties to the negotiations dispute. Even when the requirements are fulfilled, negotiations for compromise can be and often are conducted without any privilege. Each party may wish the court to know the terms upon which he was prepared to compromise. But any party is entitled to make an offer to compromise for which he can claim privilege if the negotiation initiated by his offer ultimately fail. And then towards the end of that paragraph, the purpose of the privilege, about 7 lines up, The purpose of the privilege is to prevent statements made in the course of such negotiations from being relied upon as admissions in the litigation to which they relate. If the negotiations result in an agreement for compromise, the need for the privilege lapses and the agreement can be proved like any other contract. Now, we'll come back to some of the detail of that in the context of the later stages of the argument, but the underlying purpose of the privilege is perfectly clearly and consistently identified in those three documents. And
this one, though, does seem to be limited to the case where the negotiations don't result in an agreement.
That is not, I think, necessarily consistent with subsequent authority, but we'll see the significance of that. But your Lordship is absolutely right. It is how it was expressed and understood at the time. Lord, having taken you to those academic and law report papers, I can take the authorities quite quickly, and I'm just going to go to four of them very briefly.
Just pausing there, that last article suggests that the basis of the without privilege rule is not contract.
That's right.
I mean, you could contractually agree in all sorts of circumstances that anything said between us is not to prejudice our legal position.
Lord, I was going to deal with the contractual argument separately, if I may, but it's very much the tail end point in my learned friend's argument. It may be more convenient to deal with it in reply, but the analysis that's being offered here is that the basis of the privilege is public policy. Lords, the first authority I was going to go to is Scott Paper Company, which is volume 2 of the authorities at tab 39.
Tab what?
39, my lord. And I'll just take these in chronological order, so I apologise if we have to jump around in the bundles a bit. Tab 39, Scott Paper and Drayton Paper. This was an action for trademark infringement. An application was made to cross-examine one of the defendant's witnesses on alleged admissions made, and the application was resisted on the grounds that the alleged admissions were made in the course of without prejudice negotiations. And Mr. Justice Clawson, at page 156, at line 40, says the principle seems to depend upon this, that the court has always taken the view that every facility is to be given to persons who are in litigation or anticipate litigation to come together fully and frankly, to use a popular expression, to put their cards upon the table with a view to coming to some arrangement. And if that is the position, statements and admissions made under those circumstances will not be treated as admissions against the parties. So identifying both the purpose of the privilege as being to encourage settlements and the means for achieving that, namely inadmissibility of what is said, both very clearly emerge from that very short passage. Chronologically, the next decision is Cuts and Head, which is volume 1 at tab 12. This was the question of whether or not a call the bank offer could actually be made, that is, without prejudice, save us to costs. And the judge there, Lord Justice Oliver's, as he then was, decision is often quoted. It's page 306. And he says that the rule rests, at least in part, on public policy. It is clear from many authorities, and the convenient starting point of the inquiry is the nature of the underlying policy. It is that parties should be encouraged so far as possible to settle their disputes without resort to litigation, and should not be discouraged by the knowledge that anything that is said in the course of such negotiations, and that includes, of course, as much the failure to reply to an offer as an actual reply, may be used to their prejudice in the course of the proceedings. So again, one clearly has the objective, namely encouraging settlements, and the means for pursuing that objective, namely inadmissibility of what is said.
In the course of the proceedings,
yes,
may or may not be a significant
absolutely.
limitation.
But one then moves on to chronologically to Rush and Tompkins, which is back in Bundle 2, page tab 35. Lord John Dyson may recall this. This was a case in which the plaintiff sued two defendants, settled with one of them, following without prejudice negotiations, and the second defendant sought disclosure of the without prejudice correspondence that passed between the plaintiff and the first defendant. Just for the purposes of the current submission, I just wanted to take you to page 1299 in the speech of Lord Griffiths. And this is the classic statement, which is either quoted or paraphrased repeatedly. At 1299 at letter D, the without prejudice rule is a rule governing the admissibility of evidence and is founded upon the public policy of encouraging litigants to settle their differences rather than litigate them to a finish. And almost facing at letter C on the opposite page, it's unnecessary to make any deep examination of the authorities to resolve the present appeal, but they all illustrate the underlying purpose of the rule, which is to protect a litigant from being embarrassed by any admissions made purely in an attempt to achieve a settlement. So again, just without getting into any more detail, as I say, the public policy objective and the means for pursuing that objective are very clearly identified there. And again, in the most recent case on the subject...
On the facts of Rush and Tompkins, can I just get it straight that the correspondence wasn't relevant because it was relevant to interpretation of the settlement agreement? It was simply relevant because it contained some matters which happened to be relevant in the subsequent litigation.
That's right.
So
in relation to a dispute between one of the parties to the settlement agreement and a third party.
Yes. So, I mean, it doesn't bear on the present issue, therefore, except insofar as it indicates that without prejudice can, in some measure, survive a settlement agreement.
Absolutely. Absolutely. Lord, I'll come back to the detail in relation to particular parts of our submission, but I just want to park for the moment the key point as to what the public policy is and how it sets about achieving its objective. And finally, the relatively recent decision in Afulaway and Bossert, which my Lord Walker will no doubt recall, and just for these purposes, it may be convenient to identify in the speech of Lord Neuberger.
Sorry, which tab are we?
Sorry, 28.
28, thank you.
I simply take you to this because in paragraph 85 we have a more recent 2009 affirmation of the passage I just read to you from Lord Griffiths.
Paragraph what?
85, my Lord. Between C and D, you'll see Lord Neuberger cites Rush and Tompkins, and the passage I was quoted to you, it simply affirms Lord Griffiths' explanation that the rule was founded upon the public policy of encouraging litigants to settle their differences rather than litigate them to a finish. And so, Lord, as I say, without labouring the point, the objective is perfectly clear, that is the encouragement of settlements, and the means is perfectly clear, that is inadmissibility in order to prevent parties from being embarrassed by what is said in the course of attempts to settle a dispute. The next step in our argument is this submission, that the privilege should not be allowed to exceed its proper purpose. we would submit is, in a sense, an entirely self-evident proposition. The privilege, if it applies, results in relevant evidence being excluded from the trial process. It is therefore a privilege which should be applied with restraint, and identifying its operation, its proper operation, the court should be sure that it is not extending beyond the purpose which justifies it. And the result of this, and it's reflected perfectly clearly in the authorities, that the without prejudice privilege is a qualified privilege. It is not unlike legal professional privilege, it is not an absolute privilege. It is a qualified privilege. There are numerous situations which define its boundaries, in which without prejudice material is admissible, and there are genuine exceptions in the sense that material may be admitted, notwithstanding that it is without prejudice and said with a view to settling an agreement. For example, it will be admitted by reference to what is known as the iniquity exception. I'll go to the detail in a moment, but the short proposition I'm just urging on you now is that because it is a privilege and it has an exclusionary effect on relevant evidence, it should not be allowed to exceed its proper boundaries. And one sees something of that, if you still have Ofulu and Bossett to hand, one sees something of that in the speech of Lord Scott. If you don't have it, it's tab 28 of volume 2. Lord Scott at paragraph 34 he actually was dissenting on the result in the case, but not, I think, on the statement of principle for which we are just citing him here. Paragraph 34, letter F. He says, a public policy rule should not be allowed to extend further than the public policy in question requires, and to apply the rule mechanistically without regard to the limits that the purpose underlying the rule should dictate. Cannot, in my respectful submission, be right. And one sees something similar, if I could also, with respect, go to another case we haven't looked at yet, Bradford and Bingley, and Rashid, which several of you will be familiar with. My Lord, Lord Mance, said something similar, so this is volume 1 now at tab 7. Lord Mance at paragraph 85, you had cited to you the article by Mr. Wever, which I have referred you to, and your Lordship there at paragraph 85 says, Mr. Wever submits at page 134, and I agree with him, that the without prejudice rule of admissibility should be strictly confined to the area of its legitimate utility in the facilitation of the settlement of disputes. In that area, concerning admissibility in court or disclosure, the court is, as Lord Griffith stated in Russian Tompkins, giving effect to a rule of public policy. So we would urge your Lordships, with respect, to uphold that thinking and strictly confine the privilege to the area of its legitimate utility. Lords, can I just pause at this stage and mention one other thing? There is mentioned in a footnote to Cross and Tapper on evidence an unreported decision of the Sir Andrew Morritt, the Vice-Chancellor as he was, which isn't in the bundles, which simply touches on the possible impact of the European Convention on Human Rights in this regard. It's not a detailed judgment, but it does add some complexion to this particular point about the restraint that should be exercised in applying the the privilege. And we brought a copy of that decision along if your lordships would wish to see it. It's an extremely short one, and it can be handed up if that would be of assistance.
Which article of the Convention?
The one that was cited to him was Article 10, freedom of speech. It might be suggested with some, or perhaps more force, that Article 6 would be engaged, in that the exclusion of relevant evidence would impact on the right to a fair trial. I'm not suggesting that the engagement of the articles is going to produce a different result. It may, as often happens with convention issues, provide a different language for describing roughly the same thought process as the common law has gone through in any event. Because what Sir Andrew Morritt said in that case was that it had been pointed out that Article 10 was engaged, and that therefore questions of justification would arise as to the exercise of an exclusionary rule. And all he said was that emphasised the need to exercise restraint in applying the privilege. Lord, it's quite a short point. The case then went to the Court of Appeal, and the Court of Appeal didn't find it necessary to deal with it. So I say it is very much a footnote point, and it's an unreported decision. I don't think it will add to the learning. I will move on. That in any event, with or without the European Convention, we have clearly the principle of domestic law that the privilege should not be allowed to exceed its purpose. The next step in our argument is this, my lords, that because of everything that we have said so far about the without prejudice privilege, it is the case that the privilege is not absolute, and resort may be had, and again I'm quoting, and I will take you to the quote in a moment, resort may be had to without prejudice material for a variety of reasons when the justice of the case requires it. That is something that was said in Rush and Tompkins itself. It may not be necessary to turn it up because just to give you the citation for it, it's Rush and Tompkins at page 1300, and it's at letter C, and it's repeated in Ofulue and Bossert at paragraph 58. I don't ask you to go to those just for that. Resort may be had to without prejudice material for a variety of reasons when the justice of the case requires it. And the consequence of that is that numerous situations have been recognised where the application of the privilege does not lead to the exclusion of evidence from the trial process. It is inevitably the case that the exceptions, or if they are exceptions, or the contours of the privilege have been worked out on a case-by-case basis, as the common law does, without necessarily any sort of single guiding principle being articulated in each case. The two things that one can say is that that no one has attempted to codify the list exhaustively, and no one has suggested that new categories of case cannot be added to the list if the justice of the case demands it. The list of recognised categories in which without prejudice material is admitted is not in dispute. And I can go through it again fairly rapidly, but I do want just to put in mind with you the various categories that have been currently identified, because it helps to identify the correct scope and application of the privilege, and it also helps to identify the underlying principles by reference to which evidence is or is not admitted from the without prejudice process. It also will assist in testing whether, if we get to it, we need to persuade you that any new categories of case needs to be allowed, in which without prejudice material it should be admitted to the court. The summary that is always cited of the recognised categories comes from the speech of my Lord Justice, as you then were, Robert Walker, in the Unilever case, which is bundle 3 at tab 45. The circumstances, my Lord Simon Brown will also no doubt recall the case. The circumstances of the case don't particularly matter, but what had happened was that the plaintiff in this action sought to rely on threats that were allegedly made at a without prejudice meeting to found an action under the Patents Act. So the question was whether or not the threats that had allegedly been made were admissible in evidence. And my Lord Justice Robert Walker, as you then were, identified a list of categories in which without prejudice material has been admitted into the trial process at page 244, letter C, where you said that nevertheless there are numerous occasions on which, despite the existence...
244 what?
4.
Oh, I'm so sorry. I missed a 4. 2444. Sorry. Letter C. Nevertheless, there are numerous occasions on which, despite the existence of without prejudice negotiations, the without prejudice rule does not prevent the admission into evidence of what one or both of the parties said or wrote. The following are among the most important instances, and just to repeat, your Lordship was not there purporting to set out an exhaustive list, nor is anything here said to suggest that the list is closed to any new categories developing. But just moving through them, you'll become familiar with these if you're not already. One, as Lord Justice Hoffman noted in Muller's case, when the issue is whether without prejudice communications have resulted in a concluded compromise agreement, those communications are admissible, and the case of Tomlin is an example. So obviously, if there's a dispute about whether there's been a concluded agreement, you need to look at without prejudice communications in order to see whether there's been a compromise. 2, evidence of the negotiations is also admissible to show that an agreement apparently concluded between the parties during the negotiations should be set aside on the ground of misrepresentation, fraud, or undue influence, and reference is made to an earlier case to support that. 3, even if there's no concluded compromise, a clear statement which is made by one party to negotiations and on which the other party is intended to act and does in fact act, may be admissible as giving rise to a mistoppel, and Hodgkinson and Ward's mobility is cited. 4, apart from any concluded contract or estoppel, one party may be allowed to give evidence of what the other said or wrote in without prejudice negotiations if the exclusion of the evidence would act as a cloak for perjury, blackmail, or other unambiguous impropriety. We get a string of citations for that. 5, evidence of negotiations may be given, for instance, on an application to strike out in order to explain delay or apparent acquiescence. 6, in Muller's case, one of the issues between the claimant and the defendants, his former solicitors, was whether the claimant had acted reasonably to mitigate his loss in his conduct and conclusion of negotiations for the compromise proceedings brought by him against a software company and its other shareholders. Lord Justice Hoffman treated that issue as one unconnected with the truth or falsity of anything stated in the negotiations, and is therefore falling outside the principle of public policy protecting without prejudice communications. The other members of the court agreed, but would also have based their decision on waiver. Then we get at 7, without prejudice, save as to costs, and 8, a special rule in relation to matrimonial cases. So simply by way of identifying authoritatively a list of the principal situations, we can see that. Apart from those 8, there are, we would submit, at least 2 other...
Could we just go back to 6? Lord Justice Hoffman seems to be restricting the principle to 1, protecting statements that may be true or false, but
Yes.
Here we're dealing to some extent with simply knowledge, whether one or other of the parties had knowledge.
Exactly. I will go on to emphasise that point, my Lord, when I'm making our submission as to the balancing exercise that may need to be conducted.
But Russia, I mean, the point is that Russian Tompkins adopts a broader view, doesn't it, than Lord Justice Hoffman?
Yes, and I don't think everyone in Ofuluwe and Bossert were entirely persuaded by Lord Hoffman's analysis either. Lord, I was going to suggest that there are 2 other categories of case in addition to the 8 identified in Unilever, where without prejudice material is admitted into the trial process. The first is that it will be admitted in evidence in relation to a claim for rectification. That is common ground in this appeal. Lord, and because it's common ground, I don't need to go to any authority for it. If you want a note, it is mentioned in Chartbrook, the recent decision in Chartbrook and Persimmon Holdings, which is Bundle 1, tab 9 at paragraph 42. But as I say, it's been common ground throughout in these proceedings that without prejudice material would be relevant on rectification.
Is there anything there about the explaining why it's relevant?
No.
It's just assertive that it's relevant.
It is assertive that it's relevant. My Lord, I will go on to explain our suggestions as to why it's admissible in a moment, but I just wanted to itemise the list first and then go to the rationale in a moment. The final, the second additional category of case in which material, without prejudice material, has been admitted is on an ex parte application as part of the applicant's duty of candour to the court. This is it may be helpful just to look very briefly at one authority. It's not actually mentioned in our case, but it is in the authorities bundle. It's in volume 1, tab 18. A decision of Mr. Justice Ricks, as he then was, in Gulf Interstate and Amp Trade, the Giovanna. What had happened here was that the claimant had sought and obtained a Moreva injunction ex parte. There had in fact been without prejudice negotiations going on, the content of which would be relevant to the question as to the risk of dissipation of assets. And the question therefore arose whether the fact that the claimant had been having without prejudice negotiations with the defendant, and the defendant had been making various offers which were relevant to the question of dissipation, ought to have been disclosed to the court on the ex parte application as part of the plaintiff's obligation of candour when applying ex parte. And what Mr. Justice Ricks says about that is at page 872. I won't read all the facts that he deals with. The relevant passage dealing with this starts in the left-hand column halfway down the page, dealing with what was and wasn't mentioned on the ex parte application. And if we go to the right-hand column, again, more or less in the middle of the page, of course, he says there had not yet been a concluded agreement with the owners, and all the negotiations between the two firms of solicitors were conducted, and the correspondence was all marked without prejudice. Counsel, on behalf of the plaintiffs, therefore submitted that the plaintiffs couldn't be criticised for making no mention of such negotiations. I don't agree. It may be that the correspondence itself could not have been unilaterally presented to the court by the plaintiffs, but I don't accept the Moreva injunction can be sought ex parte without at least some mention being made of the existence of an offer of security, an offer which was still current at the time when the plaintiffs went to court. Such an offer, even though there may be strings attached, runs directly contrary to the Moreva applicant's implicit invocation of the court's assistance in confronting a real risk of dissipation. It seems to me that the situation is somewhat analogous to one where there is an application to strike out an action for want of prosecution. The fact and even the contents of without prejudice negotiations can be disclosed for the purpose of explaining the passage of time and the conduct of the parties in the context of an allegation of inordinate and inexcusable delay. Your Lordships will recall that adducing without prejudice material in order to explain delay is one of the categories that were recognised in the Unilever case, and by analogy with that, Mr. Justice Ricks is saying that the duty of candour on an ex parte applicant can have a similar effect. And so, Lord, just for if not completeness, at least fullness, we thought it may be helpful to add those to those two situations to the list that has already been identified in Unilever. Now, just pulling some threads together in relation to those various categories in which without prejudice material has been admitted, we offer two observations on these cases. and this partly, I hope, answers my Lord Mr. John Dyson's question. The first submission is that the underlying logic of many, though not perhaps all, the underlying logic of many is that the admission of evidence in these circumstances positively serves the public policy on which the without prejudice privilege is based. That is plainly true, we would submit.
Namely?
Encouraging settlement. Lord, that is plainly true of allowing evidence to be adduced to prove that a contract was actually reached and what its terms are. If the public policy is to encourage parties to settle, it would, of course, make a nonsense then to exclude from evidence any document which, arguably at least, concluded the agreement. So admitting in evidence the documents which embody an agreement reached without prejudice serves the public policy upon which the privilege is based, because it reassures the parties and encourages them to reach a settlement agreement out of court, because they know if they do reach a settlement agreement, it will be enforceable because the agreement itself will be admissible. If it was inadmissible, it would frustrate the entire purpose of the privilege. And so the rationale for that particular category of admissibility is, in our submission, entirely based on exactly the same rationale as the public policy underlying the without prejudice privilege, namely encouraging settlements. You couldn't have it otherwise.
Is that how the rationale has been articulated in the cases?
My Lord, yes, I think it is, exactly. I can take you back to some. I think that's certainly how it's put in Tomlin, which was the first case. My Lord, I'll go back to them. I haven't got a note immediately in front of me where that's... but I'll take you back to that after the short adjournment.
I wonder if, just looking down the list in my Lord Walker's judgment in Unilever, it seems to me quite a lot of them could be explained as based on different rationales. You're certainly 1 and 2 fall within what you said. 3, the estoppel one would think the rationale there was that if you've said something on which you've intended somebody else, the other party, to act, what you're really doing is inviting, actually not the making of a separate contract, but you're inviting conduct outside the settlement negotiations, which has significance.
Yes.
And therefore you're stepping outside, so to speak, the without prejudice negotiations. And 4 is a public policy point, which has nothing to do with your point, does it?
No. No, I'm not stressing this.
5 also nothing.
No, the same, Lord. I'm not suggesting that this is a golden thread that runs through the whole line of situations in which evidence is admitted. But I do submit that it is present in at least 3 of them. It's present in justifying the admission of the contract. It is present also, as Your Lordship, I think, just mentioned a moment ago, in relation to the second one, so misrepresentation, fraud, or undue influence. That, again, is, in our submission, entirely rational in relation and supported by exactly the same policy. Because otherwise, parties are going to be discouraged from entering into without prejudice negotiations. Because if they believe if the law is that a contract entered into following without prejudice negotiations cannot then be set aside on the basis of fraud or undue influence, they will be discouraged from entering into without prejudice negotiations leading to any such agreement, because they will know that the court is going to apply double standards, one set of rules for contracts made on the basis of open negotiations, a different, more restrictive set of rules applicable for contracts made following without prejudice negotiations. The same can be said, thirdly, in relation to
Is there an estoppel case where the contract has been entered into?
Well, we said this is exactly one such case. We have a pleaded claim on estoppel.
That's estoppel by convention, is it? Estoppel by representation?
Representation.
Not convention?
It's pleaded as an estoppel by representation. I think one only needs, in a sense, to resort to an estoppel by convention. The two are extremely close, but I think one only may need to resort to an estoppel by convention if you don't have a representation. If you do have a representation and the parties then conduct themselves on the assumed basis that that representation is true, then we would box that as an estoppel by representation. But it has very much the same features as an estoppel by convention, namely two parties acting on the assumed basis that X is the case.
Does Mr. Justice Neuberger give some reasons for his, or some policy reasons for his conclusion?
Lord, he does, but I was going to deal with estoppel separately at the end, if I may. And I'll come back to this.
But they're closely related, aren't they, really?
Yes. Yes, they are. But as I say, my Lord, just in order to give some structure, I was going to come to estoppel separately later.
The third category, which I think you were going to mention, which is clearly consistent with your general principle, is rectification.
Indeed. And again, my Lord, exactly the same point can be made. If the law was that evidence was admissible in order to rectify a contract, in order to ensure that the words reflected the true agreement between the parties, only in relation to contracts which have been made on the basis of open discussions and not in relation to contracts which have been made on the basis of without prejudice negotiations, it would discourage without prejudice negotiations, because people would know that if something went wrong with the language, the court would not be equipped to put it right. And that would plainly discourage the parties from entering into settlement negotiations on a without prejudice basis. Lord, there is something that one gets, actually. My Lord John Dyson asked me a moment ago if the point has been articulated in this way. One sees some of that, certainly from Cuts and Head, which is back at Bundle 1, tab 12. In the speech of Lord Justice Fox at page 315 to 316. And at 315, it's just at letter F, halfway down the paragraph, the matter only arises upon the question of costs after the issues have been decided. As to that, I'm not convinced that the reservation as to costs would inhibit a reasonable compromise. If a party is exposed to a risk as to costs, if a reasonable offer is refused, he's more rather than less likely to accept the terms and put an end to the litigation. On the other hand, if he can refuse reasonable offers with no additional risk as to costs, it's more rather than less likely to encourage mere stubborn resistance. Furthermore, the existing practice, both under the rules of the court and other procedures, is difficult to reconcile the existence of any public policy objection to the call-the-bank type of offer. Thus, the procedure under the rules for payment into court in cases where a debt or damages are claimed is in effect a call-the-bank procedure. Since the fact of the payment into court can't be referred to until the issue of liability has been determined, it then becomes material on the question of costs. And he mentions other examples. In the circumstances, he says at B on 316, in the circumstances, I don't think we would be justified in rejecting call-to-bank offers on grounds of public policy. In principle, they are more likely to fulfil than to frustrate the public policy of facilitating compromises. And we have no reason to suppose that in the various jurisdictions to which I've referred, where something akin to the call-to-bank offer has been operated over a substantial period, the practice has been found in any way unsatisfactory, or that any criticism of it has developed. So that is an illustration of the point live in a decision. As I say, I'm not suggesting this is the golden key that unlocks everything in without prejudice, but we do suggest that it is a critically important principle that runs through a significant proportion of the case law, which identifies the circumstances in which without prejudice material is admitted. The other point that we saw from the second point that we just wanted to urge on you is this, that in sorting out what the appropriate boundaries of admissibility or inadmissibility are, the court works by way of analogy with the established categories. And one saw that expressed in the Gulf Interstate case, the ex parte Moreva application case a moment ago, where his lordship expressly referred to the category that had already been established of admitting without prejudice material where the question was justifying a delay. And he said, by analogy with that, there ought to be admissibility in relation to an application ex parte, where the without prejudice negotiations are relevant to the issue on the Moreva application of a risk of dissipation. So, my Lords, against that background, we can then move to our first main argument, a lot of which then falls into place because the bricks are all roughly in place already. Our first main argument, as I say, is that this material should be admitted because admitting it positively supports the public policy on which without prejudice privilege is based, namely the encouragement of settlements. That is the key point. A subsidiary point, although it really is just the corollary, is that there is no good policy reason for excluding this material. And another subsidiary point, or a different way of saying the same thing, is that by very close analogy between this case and the established categories in which without prejudice material has been admitted, we say, applying the analogy approach, that it also provides a strong argument in favour of accepting admissibility in this case. Just dealing in a little more detail with each of those points, we are serving the same public interest as the policy, the public policy on which the without prejudice privilege is based, simply because the material on which we seek to rely is relevant, assumed to be relevant, to the interpretation of the settlement agreement. The public interest on which the without prejudice privilege is based would be positively advanced by admitting that evidence, and indeed it would be undermined by refusing to admit it, because the material is, by definition, necessary for the court's consideration and ascertainment of the true meaning of the settlement agreement. It is necessary in order to achieve what the courts regard their job as being, namely, to understand, despite the imperfection of language, what these parties actually meant. If the court is disabled from understanding in the proper context, which all the ICS and Bromwich and Manai and Reardon-Smith cases tell us is relevant, if the court is disabled from applying the approach which it regards as the right and necessary approach in understanding what these parties meant by these words in the particular context, then it is less able to do justice by reaching a proper understanding of the true meaning of this contract. And if that is the position that the court is left in, it will discourage without prejudice negotiations, because parties who are contemplating the possibility of without prejudice negotiations will know that if they reach an agreement, the court will be less well equipped to understand what they meant.
Well, I mean, there's maybe an element of circularity. If they do actually know that, I mean, if the lawyers say to them, look, the law doesn't allow any reference to surrounding circumstances, so you must make sure when you contract that you include all the circumstances which are relevant in the contract.
Lord, the ingenuity of lawyers, no doubt, will attempt to mitigate any disadvantage which the law inflicts on them. The question, however, is whether the law should inflict that disadvantage in the first place. And our submission is that there is simply no good reason for doing so. The line of authorities I took you through at some length of River Weir and Brennan Simmons and ICS and Bromwich and so on explain why the court needs to see the factual context. What the Court of Appeal has said in this case is the court is not allowed to see the factual context. It is less able to come to the right answer.
Unless you state it in the contract.
Unless you state it in the contract. But any practitioner, and I'm sure any judge will recognise, that the factual circumstance which ultimately becomes relevant in a dispute is the one that everybody took so for granted that it didn't get into the contract. Almost always disputes arise in relation to that which is unforeseen. So, simply assuming that the perfect lawyer would be capable of avoiding any problems that this rule would inflict by writing everything into the contract would simply generate telephone directories rather than two-page agreements. And we know, I mean, this case is a very, very good illustration of exactly why the problem arose, because the parties were under some time pressure. They agreed this in the course of negotiations over 2 days, and in fact intended, as one sees from the beginning of the settlement agreement, to reduce it to a more full agreement. They just didn't get round to doing it. And that is what happens. That's what happens in the real world, and that is why we started by emphasising to you what was said extrajudicially by Lord Gough and Lord Steyne about the court's function of oiling the wheels, not putting grit in the oil, not putting a spanner in the works. The object of the exercise is not to make things more difficult, not to require lawyers to write telephone directories, but to put the courts in the best possible position to understand what they did mean, having written something on the back of an envelope under some time pressure. And so that is why we say that it would simply be a discouragement to, without prejudice negotiations, to have a different set of rules that applies to the interpretation of agreements that have been reached as a result of those, from those that apply in relation to agreements which have been entered into following open negotiations. It just creates a second-class contract which the court is less able properly to understand. And there isn't a good policy reason for doing that. Indeed, as I say, quite the converse. We say that by discouraging it would discourage parties from entering into without prejudice negotiations, because they would know that the product of those negotiations would, in the court's eyes, be less able to be properly understood. And so that essentially is the core of our first and main argument. The corollary to it, as I say, is that there is no good policy reason for reaching that conclusion. In this context, we will go on in relation certainly to our second main argument to explore the particular factual situations in this case which make it particularly appropriate to admit this evidence. I will address you at some length on the particular features of this case under the heading of our second argument as to why the material should be admitted. But the same considerations would apply equally in this case.
Isn't there a more fundamental point that it's part of the exercise of finding out whether the parties have reached a settlement? Now, maybe said if they've recorded it in a formal written document, you don't need to go any further. But that's really looking at the rule excluding extrinsic evidence. But you might not have a formal written document. There might be an issue as to whether the parties had orally agreed a compromise. You would then have to look at what they had said, whether they had reached agreement on terms, and what those terms were.
Yes.
And you can't identify what the terms are without looking at relevant evidence which bears on the question of what the words they used meant.
Lord, I would gratefully adopt and echo that. My Lord, the other point I was proposing to make in this context, it is really just to flesh out the point I have already made, by way that the argument can advance by way of analogy. Again, as I say, all the pieces are in place for that. We submit that there is a very, very close analogy between admitting material in order to prove the existence and the terms of a contract and admitting material as an aid to the correct interpretation of the contract and admitting material in order to rectify the contract. Of course, conceptually, you can describe what the differences are between those various processes, that is, identifying what the terms of the contract are, understanding the terms of the contract, and, if necessary, rectifying the terms of the contract. conceptually you can describe the differences between them, and indeed the Court of Appeal in this case did. They said, well, rectification is about correcting the words on the page to reflect the true agreement, whereas interpretation is a question of understanding the words on the page. But with the greatest respect, that is describing a difference that doesn't really advance the analysis in this case at all, because identifying the terms of the contract, understanding the terms of the contract, and if necessary, rectifying the terms of the contract, are all part of exactly the same process, which is to give effect to the reasonable expectations of honest businessmen by providing an effective, fair framework for their contractual dealings. And indeed, the line between interpretation and rectification is almost invisible if you think back at what was said in Manai about the risk that people simply use the language in the wrong way. They talk about allegories on the banks of the Nile. They use the wrong words, and the court, by a process of interpretation in Manai, is prepared to read 12th of January as meaning 13th of January. It's doing that, it is actually correcting the words on the page as part of the process of interpretation. It's not rectifying the contract there. That's what the Lord's House was saying there. They were not rectifying, they were interpreting the contract to mean something other than what it actually said, because it was obvious that that is what the parties meant. Now, that being, and we would urge you that that is absolutely the right approach to the process of interpretation, you can only do that by knowing the context. And the context which you are admitting informs your understanding. And so the conceptual distinction between interpretation and rectification is almost invisible. The only difference between them, and this in our submission is a point strongly in our favour, the only real difference between interpretation and rectification is that rectification actually allows in a wider category of documentation than interpretation. Interpretation, which is all we're asking for, admits relevant factual matrix evidence. Rectification, as we all know, allows in the kitchen sink, because you trawl back through the negotiations between the parties to see if you can tease out from them some prior common accord, which is then not reflected in the written document. So we are in fact urging on you the admission of a smaller category of evidence, factual matrix evidence, than has already been recognised as being admissible in relation to rectification. So in that sense, working by analogy, we are making a plea for a more modest admission of a category of evidence than has already been recognised.
In fact, I mean, the consequence of the Court of Appeal's decision would presumably be that since you can't interpret by reference to the surrounding circumstances, there'll be more attempts to rectify contracts which, if the context had been omitted, might not have needed rectification.
Well, that, I suspect, would almost certainly be the practical consequence. I agree. Now, that is...
I imagine thinking in relation to the 12th, 13th of January point, you don't get to rectification because of the interpretation.
Yeah, you don't need to.
You only need to rectify.
But you only know it means the 13th because you know the factual context.
But if the party had actually simply claimed rectification, rectification would have been ordered. I mean, it would be another way of achieving precisely the same result.
It may well be, absolutely, which again is more close to our analogy argument.
But logically, you shouldn't reach the rectification until you've decided what it means.
Indeed. No, you're absolutely right. Which is exactly what happened in Pren and Simmons.
You say you're trying to fill in a gap.
Yeah. So that's our principal line of argument, and if you're with us on that, then we don't need any further argument. If you're not, then our second argument is presented on the assumed basis that you regard there as being some competition between the public interest on which the without prejudice privilege is based and the public interest in favour of admitting this material. The public interest on which without prejudice privilege is based is encouraging settlements. The public interest in favour of admitting evidence of the factual context could be described as being the public interest in achieving the right result. The court oiling the wheels, understanding correctly what the parties meant. If it is put like that...
I mean, I think, as I understand, Mr. Sheffield, I mean, that I think really is what he does it. I mean, he says, OK, well, you might get the right result in this case, but you're going to discourage negotiations in the future. You're going to whittle down the effect without prejudice and discourage people entering into without prejudice negotiation in the future. He may be right or he may be wrong, but I think that's, as I understood it, I may be wrong, basically what he would say is the countervailing public interest.
Well, Lord, as I say, for the reasons I've suggested in our first argument, we just say that is wrong. Because factual matrix evidence, in a sense, is blind as to who is seeking to adduce it and who generated it. It is simply part of the factual background. It's completely different from admissions against interest. It is a neutral fact. It may help one side, it may help the other. But what it does do is make sure that the court is more likely to get to the right answer. And if both parties know that the court is more likely to get to the right answer by admitting the factual matrix evidence, both parties will prospectively, and all future parties in litigation yet to come, all parties will know that they are safe in entering into without prejudice negotiations and safe in concluding an agreement.
But that's your first point.
Yeah, sorry.
If the first point fails, then the authorities are against you, aren't they? Because they say
if my first point
that
fails,
the without
then
prejudice principle trumps, if you like, having all the relevant evidence point. There's one of the cases says that.
Well, Lord, the question then is, well, where does the balance fall in this case? Because without prejudice is not an absolute bar. We've seen that from the various categories in which it has been admitted, and from the clear statement repeated in Ofulu and Bossett, the clear statement in Russian Tompkins, that without prejudice material can be resorted to in a variety of situations where the justice of the case requires. Now, we submit, our second argument is that the justice of the case does require it here for a combination of reasons. And I just run through those reasons and explain why the balancing exercise in this case should be regarded as favouring the admission of the material. The principal propositions on which this is based are really already before you. That is that unlike legal professional privilege, the without prejudice privilege is not absolute. And we've seen numerous situations which have been identified where material is admitted, despite the fact that its origins are within without prejudice negotiations. And so what we urge on your lordships is that if you do come to the conclusion that there is a competition between two conflicting public interests, then what you've got to do is balance which one trumps the other. And the answer is not, oh, well, it's without prejudice, therefore it is inadmissible, because that is simply not how the authorities have worked. It is inadmissible if the justice of the case requires it to be inadmissible. But in the numerous situations we have seen, the justice of the case does not require it to be inadmissible. Now, the particular circumstances in this case, which militate in our submission strongly in favour of admission, are these. The first, this may seem, in a sense, a blindingly obvious point, but it isn't actually quite so obvious. The first point is that the material is relevant.
Well, that's surely a truism. If the material is not relevant, it can never prejudice. It shouldn't be admitted because it's not relevant.
That is precisely one of the key justifications for excluding without prejudice material. Because the thinking is, well, people often say things and do things to get rid of a claim, not because they are in fact admitting that they've got a bad case or that the claim is good, but they are simply, in one of the language of the older cases, they are buying their peace. And one of the original justifications for excluding from admission without prejudice material was that things that you said in order to try and settle a case are irrelevant because they are not evidence of your liability. They are simply an illustration of the fact that people often agree to buy off nuisance claims.
Well, I wonder if it's fair. It is an agreed fact, I know that this material is relevant, but Mr. Schaff's case is redolent of the proposition that it's the kind of material that may or may not be relevant. Yes. And you're not going to know whether it's relevant until the court has been asked to look at it. And so if you're going to say it is admissible, that's going to let into the trial a lot of stuff which at the end of the day is held not to be admissible.
It may, if at the end of the day the argument on relevance is defeated. But it's difficult to see where that argument goes, my lord, because if the objection is, well, that's going to overload the trial with a material which ultimately proves to be inadmissible, that would be an objection to the admission of factual matrix evidence in any case. And
you say that the judge is going to have to decide whether it's relevant in any event, just like any other.
Yes, exactly. And that's not going to overburden the trial process. And if the judge comes to the view that the material is inadmissible, he makes his decision without reference to it. And that is not a conceptually difficult thing. It is something that happens whenever a judge rules that something is inadmissible.
It must also arise whenever allegations of misrepresentation, undue influence, or in support of a rectification plea are put forward which prove to be wholly hopeless.
Absolutely. It happens in spades in rectification cases, but the judge will no doubt see a huge amount of material which he ultimately, I mean, in 9 times out of 10, as we know, is held not to be relevant.
Well, could I put it another way? Is it really fair, when we're dealing with the question of principle, for you to be able to say, on the facts of this case, it's agreed that it's relevant, therefore it ought to be allowed in?
Well, my lord, it's not agreed to be relevant, but it's not in dispute before you that it is at least arguably relevant. And arguable relevance is the test for admission of factual matrix evidence.
It's surely irrelevant whether it is relevant.
Exactly. Well, just to give a couple of pegs to hang that point on, I said to you that one of the earliest and most fundamental justifications for excluding without prejudice negotiations was the fact that they are regarded as being irrelevant because a man is entitled to buy his peace. One sees that from the case of Tennant and Hamilton, which is Authorities Volume 3 at tab 42. This was a case where a defendant was being sued for nuisance, and an attempt was made to cross-examine one of the defendant's witnesses as to whether or not he'd paid any sums to settle claims by other claimants who had complained about the same nuisance. And so the question of the relevance and admissibility of that line of evidence arose, and at page 1018, the Lord Chancellor said this, just about a quarter of the way down the page: upon general principles, the rule of law in this country and in Scotland must be the same. If a pursuer calls a witness and asks him as to money being paid for alleged damage, his answer in the affirmative is not evidence of actual damage. If the pursuer had made a claim upon the owners of the manufactory for damage done to his field from the smoke and vapour emitted, and the owners had given money to quiet his complaint, that would be no evidence of the damage. It's money paid to buy peace and to stop complaint. It's very often a wise thing, however unfounded a complaint may be, for parties to pay a sum of money in order to quiet the party making the complaint. But this does not rest merely upon general principles. The rule of law in this country has been cited by the appellants, and from the authorities cited by them, it appears there is no distinction between the two countries in this respect. And so, just again, it may be convenient to look very briefly at to academic commentaries rather than going through a whole string of cases. There's an article we haven't looked at yet, quite an old article, but again, it's been cited in previous cases by Mr. Tracy.
Mr. Weber, or Professor Weber.
Weber deals with it as well. Weber deals with it as well, but Mr. Tracy deals with it in tab 57. This is an American article from the 1930s. Given the antiquity of the rule, it's none the worse for that. At 526, in the Michigan Law Review, when he's just going through the different justifications that have been advanced for the without prejudice privilege, and he says the third,
Sorry, 9 what?
tab 57,
Yeah,
page 526,
526.
just the second sheet. Just over halfway down, the third and most widely accepted theory upon which offers are excluded but statements of independent fact are admitted is that offers are irrelevant but facts relevant. An offer is an individual's appraisal of the worth to him of having a dispute settled rather than an admission of the measure of liability. Settlement is referred to as buying peace. The premise conceded, the line of relevancy logically falls between offers and independent facts. In the next tab, Mr. Weber's article touches on the same point at page 101.
But statements of independent fact aren't admitted, are they? In this jurisdiction?
Well, there is some authority that they are, and it's not something that we're arguing in front of you.
There's
It's
the very
little bit
ancient
open.
case of Waldridge and Kennison, which
Exactly.
is mentioned, in fact, in the Tracy article at 528, but
That's
I
right.
had noted that you weren't putting it in the forefront of your case.
It hasn't received the sort of most encouraging reception recently, my lord, so we're going to leave it where it was in the 18th century, I think. In Mr. Weber's article, which is tab 58, he touches on the same point at page 101, conditional statement, and he said Professor Wigmore has been the most influential proponent of the theory that the without prejudice rule is based on the irrelevance of hypothetical or conditional statements. And he then gives two quotations. I won't read that, but that page then again provides a helpful illustration of that point, exposition of that point. And so, as I say, our first argument, and I'm not saying that any one of these is of itself determinative. We're not saying it's relevant, therefore it should go in. The position is not that straightforward. And so what we are saying is that the accumulation of factors in this case leads to the result that it tips the scales in favour of admission. And one of the relevant factors is that this material is relevant, unlike a lot of what is said in without prejudice negotiations. And it's relevant because it's part of the, assumed for this appeal, to be part of the factual matrix. And the second point, again, it may be a different way of saying something similar. The second point is that we are dealing with fact, not admissions. This is, we are not seeking to invoke against a party an admission against interest. And you may have noticed from the authorities we were looking through earlier this morning that very often the privilege is described and justified by reference to the desirability of preventing people from being embarrassed by having admissions thrown back at them in the trial process. What we are seeking to do here is not to take advantage of an admission against liability that was made in the course of the without prejudice.
As a general rule, includes both facts and admissions. As my Lord Walker, I think, in one of the cases, says that
Indeed,
no line is to be drawn between admissions and other material.
My Lord, we're not seeking to re-argue the point that was quite rightly decided in the Unilever case, and your Lordship is right. It may be convenient just as the other members of the committee have it in front of you. It's Unilever, page 2448.
Tab.
24. So I'm sorry.
No,
Sorry, bundle 3, tab 45. And it was I think most helpful if one picks it up at 2448, where His Lordship said at letter H, in those circumstances, I consider that this court should, in determining this appeal, give effect to the principles stated in the modern cases. And he cites the ones mainly we've seen. Whatever difficulties there are in a complete reconciliation of those cases, they make clear that the without prejudice rule is founded partly on public policy and partly on the agreement of the parties. They show that the protection of admissions against interest is the most important practical effect of the rule. But to dissect out identifiable admissions and without protection and withhold protection from the rest of the without prejudice communications, except for special reason, would not only create huge practical difficulties, but would be contrary to the underlying objective of giving protection to the parties, in the words of Lord Griffith, to speak freely about all issues in the litigation, both factual and legal, when seeking compromise, and for the purpose of establishing the basis of compromise, admitting certain facts. So, Lord, we're not seeking to re-argue that point. We are not saying, because it's not an admission, therefore it is admissible in evidence. But what we are saying, and we would emphasise what His Lordship said at the bottom of the page, that the protection of admissions is the most important part of the privilege. Now, I entirely accept, for the reasons given there, that in a sense for pragmatic reasons, the courts don't sit down and fill it out, what is an admission from something that's not an admission, in all cases. But that pragmatic approach should not be allowed to turn the privilege on its head and lead to the result that one assumes that the public policy on which without prejudice is based necessarily requires things which are demonstrably not admissions to be excluded. What His Lordship was saying, what he intended to convey, no doubt will be best articulated by him. But what we would urge is that what was said in that case is not authority for the proposition that material must be excluded in all cases, even where it's not an admission, and the fact that it's not an admission is wholly irrelevant to the question whether it should be admitted. All we are saying is that the fact that this is demonstrably not an admission is a relevant factor. It's not a determinative factor on its own, but it is a relevant factor in the balance in deciding whether or not this material should be admitted.
Mr. Chair, I appreciate here we're on your second argument and this is a balancing exercise, but just reverting to your first argument, you say even if this background fact is an admission which one party is, so to speak, throwing back into the face of the other, a without prejudice admission, you say that nevertheless it still serves the same public interest?
No. Well, if it was an admission...
Yeah?
If it was an admission against liability, then its exclusion would be required by the public policy on which without prejudice is based, because its exclusion would encourage parties to settle, because if an admission is allowed in as evidence, then parties would be discouraged from negotiating with cards on the table. It's the fact that it's not an admission that means that its admissibility in evidence pursues the same public policy.
I'm sorry, I'm just asking you in the context of your first main argument.
Yeah.
I thought your first main argument was that, if it's a relevant background fact, as an admission could well be, then in order not to have a second class of contract, the same public interest...
I misunderstood your question. Your Lordship is positing a situation in which something is both
Absolutely.
a relevant fact,
Absolutely.
contextual fact, and an admission.
Absolutely.
Lord, could I have time to think about that? Because that's not a hypothetical that I think we've engaged with, and I'd just like to consider what the answer is.
Yes, thank you.
Well, I'm afraid I don't understand the difference between an admission and a statement of fact that operates prejudicially to the person who states it?
That may be the answer I give after the short adjournment.
Just while we're on back to your first point, you said you might come back after the short adjournment to a case on the first exception. I think that Tomlin and Standard Telephones at tab 43 is quite interesting because it's a question of whether there'd been a settlement of part of a claim.
That's right.
And they had to look at the whole lot. But you may possibly think it worth coming back to that.
Well, I'm grateful, yes.
There is a difference between a statement of a fact and proving a conversation which conveyed knowledge from one party to another. If there might be no issue at the fact at the end of the day at the trial, it might be quite plain that there was sleeving. And the only thing you would want to establish, perhaps, was knowledge of that fact.
Yeah.
And sleeving is said to be a fact. But it's not necessarily an admission at the time it's made. It depends which way the market goes. It may be beneficial or not.
Exactly.
But
that's right. That is very much why we say that there is a conceptual distinction between factual matrix evidence, which is blind in a sense as to which party it benefits, and an admission against liability, which is something that can only cut one way. That is precisely why we say there is this very clear distinction between the two categories, which is in fact the point I was on right now. Lord, I was just about to go to a couple of authorities on this distinction between admission and fact. I don't know if now would be a convenient moment or not. I know it's a little early, but...
Yes, no, we'll come back to it at 2:00.
I'm obliged.